The Oxford University Obligations Group have said that good faith is a topic that has been written about at an inordinate length by an almost intolerably wide group of people. Some worth reading, some not. But fear not, dear viewers, this talk is going to be fascinating. You've got to have faith. What are we going to cover? Well, we've done bad jokes. I can't promise there won't be any more of those. Then I'm going to touch on construction and implication of terms, before dealing with good faith in relational contracts, and finally talking about negotiations in good faith. At that point, I'll hand over to Chloe, who's going to talk about the vexed issue of contractual discretions, what they are, how we go about identifying them, and the intensity with which the court reviews those discretions. So what are we talking about? What is the issue with good faith? Well, the starting point is that unlike many other civilian jurisdictions, and indeed some common law jurisdictions, there is no general doctrine of good faith in the English law of contract. Why is that? Well, a number of different justifications have been suggested. First, it's been suggested that the English capitalistic conception of each individual maximising their own interest, even where that's at the expense of their contractual counterparty, justifies the absence of good faith. Second, it's said to promote certainty, and as we explore the topic, we'll see the uncertainty that the implied duty of good faith might bring. And finally, it's perhaps a reflection of the historic diet of the commercial court. Traditionally, the diet was shipping and commodities cases, the sorts of contracts where it might be thought an implied duty of good faith is less apt. But the world has changed. We now see much more complex long-term contracts, the sorts of contract which need to be able to respond to changing circumstances. And I think that's why we've seen a real proliferation of case law on the issue of good faith. And I think that's also why we've seen a lot more case law on discretions, because you need to write in discretions into your contract if you want that contract to respond to change. Now, before we delve into good faith proper, I want to briefly touch on construction and implication of terms. Now, this will be really familiar to all of you, so I'm going to hop through it pretty quickly. But the key takeaway is that in both construction and implication, there's been an evolution in approach over the past 20 years. In construction, we saw the battle between textualism and contextualism. Contextualism had the upper hand in the noughties and the first half of the last decade. Cases like ICS, Chartbrook and Rainy Sky. But Arnold and Britton put contextualism firmly back in its box. And Lord Neuberger made the point that a court should be very slow to reject the natural meaning of a provision. So the focus now, of course, is on the words used in a contract. And that's important because a lot of the case law on good faith started out in that pre-Arnold and Britton era. We see a similar evolution when it comes to implication in fact. Now, of course, as you'll be aware, there are two principal ways of implying a term into a contract: implication in fact and implication in law. M&S and BNP Paribas, again, Lord Neuberger, this is the leading case on implication in fact, and it sets out that classic test that we're all familiar with. To imply a term, it must be so obvious as to go without saying, or to be necessary for business efficacy. And this marked an express rejection of Lord Hoffman's, what I like to call his grand unified approach to implication and construction in the Belize Telecom case, where he said, there is only one question in both construction and implication. Is that what the instrument, read as a whole against the relevant background, would reasonably be understood to mean. And Lord Neuberger rejected this because it might be interpreted as suggesting that reasonableness is a sufficient ground for implying a term. Now, again, that's important because the case law on good faith first came about in that period before M&S and BNP Paribas. What about implication in law? Well, the leading case here is Gies and Soc-Gen. Baroness Hale explained that implication in law is a class, terms which are implied into a class of contractual relationship as a necessary incident of the relationship concerned. How do we go about implying such a term? Well, Baroness Hale cited the judgment of Lord Justice Dyson in the Crosley and Faithful case, where he said that it is better to recognise that, to some extent at least, the existence and scope of standardised implied terms, i.e. terms implied in law, raise questions of reasonableness, fairness, and the balancing of competing policy considerations. So that reasonableness test that was rejected when it comes to implication in fact comes back in a different guise when we're dealing with implication in law, and that's going to be important. And so on to the case of Yam Seng. Now, this was a case concerning a contract for the distribution of Manchester United branded aftershave. For me, this case is most interesting because it strikes me as odd that someone thought selling the allure of smelling like Wayne Rooney was a good business idea. Nevertheless, that was the product that was being distributed. And for most people, this case is significant because it's the leading authority, or the first authority, where an implied term of good faith was found in a commercial contract in English law. Now, the starting point for that process, and this is a judgment of Mr. Justice Leggett, as he then was, the starting point of his judgment was Lord Hoffman's test in the Belize Telecom case. You'll recall, of course, that that test is no longer the test for implying terms in fact. The factual matrix, or the backdrop against which reasonableness was to be assessed, included the shared values and norms of behaviour of the parties. And so the judge went on to say that the basis of the duty of good faith is the presumed intention of the parties. Perhaps a softer test than we're used to for implication in fact. And so he went on to imply a duty of good faith. After that, there were 10 or 15 paragraphs where he set out the policy justifications for a duty of good faith and went on to suggest that a duty of good faith should be implied into relational contracts, such as the contract in Yam Seng. He explained that such relational contracts, as they are sometimes called, may require a high degree of communication, cooperation, and predictable performance based on mutual trust and confidence, and involve expectations of loyalty which are not legislated for in the express terms of the contract, but are implicit in the parties' bargain. And the judge cited some examples of relational contracts. These included JV agreements, joint venture agreements, franchise agreements, and long-term distributorship contracts. Now, notwithstanding his exposition of the policy justification for good faith in relational contracts, ultimately the ratio of this case was that a term was implied in fact in the contract before the judge. Mr. Justice Leggett returned to the topic of good faith in his last judgment, or the last trial he heard as a first instance judge, and that was the Sheikh Tahnoon and Kent case. Now, it's important to note that by the time he came to hand down judgment, he had been elevated to the Court of Appeal. So it was Lord Justice Leggett giving judgment, but it is a first instance decision. Now, the Sheikh Tahnoon case concerned an oral agreement between two joint venture partners. The agreement was that the Sheikh would invest in Mr. Kent's hotel business by way of an equity investment, so a share investment, not a loan. Sometime after this investment, Mr. Kent's business fell into some difficulty and he needed to sell part of the business to raise money. The Sheikh withheld his consent for this sale unless Mr. Kent repaid the investment, effectively turning the equity back into debt. Now, the decision is significant or interesting for two reasons. The first point is the very helpful distinction the judge drew between fiduciary duties and duties of good faith. So he rejected the notion that Sheikh Tahnoon was Mr. Kent's fiduciary, but he did find that the contract between them was relational. And the distinction was this. He said, relational contracts involve trust and confidence, but of a different kind from that involved in fiduciary relationships. The trust is not in the loyal subordination by one party of its own interests to those of another. Rather, it is the trust that the other party will act with integrity and in a spirit of cooperation. The second significant part of this judgment was that not only did the judge imply good faith as a matter of fact, but he also implied good faith into relational contracts as a class by implication of law. And what did he say? He said, the legitimate expectations which the law should protect, i.e. he's making a normative judgment here, in relationships of this kind are embodied in the standard of good faith. Now, as I say, this is a first instance decision, but Lord Justice Leggett is now Lord Leggett in the Supreme Court, and so it carries serious weight and significance. Lord Justice Leggett's approach in the Sheikh Tahnoon case was followed in Bates and Post Office, where Mr. Justice Fraser implied a duty of good faith because he found the contract before him was relational. So then the question becomes, how do you identify a relational contract? And Mr. Justice Fraser identified 9 characteristics. The first and most important, and the only showstopper really, was that there should be no express term preventing a duty of good faith from arising. And the others were indicia of what a relational contract would be. Typically, it would be long-term, where the parties would intend their roles to be performed with integrity and fidelity to their bargain, where they were committed to collaborating with one another, where the spirits and objectives of the contract were not capable of exhaustive expression in writing, or simply weren't exhaustively expressed in writing, where the parties reposed trust and confidence in one another, though not a fiduciary level of trust and confidence, where there was significant investment by the parties, and also exclusivity of the relationship would be another indicia of a relational contract. Now, since Bates and Sheikh Tahnoon, there's been a little bit of a pushback against that notion that you should imply a term of good faith as a matter of law. One example was the UTB and Sheffield United case, where Mr. Justice Fancourt said that his preference, rather than seeking to identify and weigh the likely indicia of a relational contract, he considered it preferable to ask oneself whether a reasonable reader of the contract would consider that an obligation of good faith was obviously meant, or whether the obligation is necessary to the proper working of the contract, i.e. The Arnold and Britton test. UTB was followed by Mrs. Justice Falk in Russell and Cartwright, but the Bates approach was followed in Wales and CBRE. Now, there's been a couple more very recent cases where a duty of good faith was not implied. One was the case of Morley and RBS. Here, there was a lending agreement with a medium-sized property business, and Mr. Justice Kerr, in very brief terms, essentially said look, this is an ordinary banking contract, we're not going to apply duty of good faith into it. Perhaps giving greater analysis, the judge in Cathay Pacific and Lufthansa also declined to imply a duty of good faith into what was an aircraft engine maintenance contract. Now, the judge's approach in this case was a dual approach. He considered both whether the contract was a relational contract, and so whether he should imply the term of good faith as a matter of law, but he also considered whether he should imply the duty of good faith as a matter of fact. Now, in the Cathay Pacific case, the judge held that the contract before him was not relational because the parties, it was clear that they did not wish to be taken to rely on trust and confidence in each other to further their aims, but instead it was obvious that they wanted to rely on the commercial terms of the contract. The judge also remarked that a contract for services was perhaps not an obvious candidate for the duty of good faith. I think both of those cases reflect an understandable degree of judicial skepticism around the duty of good faith. But once you have that duty, what can you do with it? What does it mean? Well, Lord Justice Bingham in the Interphoto case summarised it as, in essence, a principle of fair, open dealing. Mr. Justice Leggett gave us some more detail, some more colour in the Yam Seng case. He said that the duty would exclude behaviour which was improper, commercially unacceptable, or unconscionable. He said the duty was concerned with fidelity to the party's bargain. Obviously, deceitful conduct would be in bad faith, but it also captured conduct falling short of deceit. For example, where a party makes a representation and after the representation is made, later learns that the representation was untrue, or that the representation has become untrue, or where a party gives evasive answers to a question. Both of these might be considered to be conduct falling short of deceit, which is captured by the notion of bad faith. In certain circumstances, the judge held that a duty of good faith could include a positive duty of disclosure. And in the circumstances of the distributorship agreement in Yam Seng, a very specific implied term was derived from the duty of good faith, and that was that the producer had a duty not to undercut the prices that the distributor could sell the aftershave at. There are further examples of the content of the duty of good faith in the cases I've set out on this slide. So the first, CPC and Qatari Dia, was a judgment of Mr. Justice Voss, and it concerned an express duty of good faith. So the duty of good faith was written into the contract here. And the judge sought to identify a common purpose. And he said the common purpose in that case was the parties' common objective of seeking to obtain appropriate planning consent for the redevelopment of Chelsea Barracks in the shortest possible period of time. And that adherence to that spirit and common purpose defined the content of the duty of good faith. In the Sheikh Tahnoon case, Lord Justice Leggett derived two very specific duties from the duty of good faith. Firstly, that the parties couldn't use their position as shareholders to obtain financial benefit at the expense of the other shareholder. And secondly, that one shareholder couldn't sell his interest in the joint company secretly from the other shareholder. The Bates case was a case concerning a detailed and carefully drafted contract between the post office and the independent subcontractors responsible for running post office branches. This contract contained very detailed terms governing an IT accounting system that those independent contractors were required to use. As I mentioned above, the judge found that that contract was subject to a duty of good faith. And from that duty of good faith, the judge derived something like 22 different specific implied duties. These included duties concerning specific elements of the IT system, specific implied rules about accounting, record keeping, transparency, and even a positive duty on the post office to provide training to those independent subcontractors. The New Balance and Liverpool case is a helpful case because it illustrates the limits of the duty of good faith. Now, the issue in that case was whether New Balance had, in good faith, estimated the number of shops in South America in which it could sell Liverpool Football Club jerseys. The judge found that New Balance's estimate was formed on the basis of an honest inquiry. That is to say, the board, when supplying the estimate to Liverpool FC, asked some sensible questions from the relevant people in South America and got some sensible answers, broadly speaking. But the estimates weren't prudent estimates, and the process of obtaining those estimates wasn't the sort of prudent approach that a reasonable man would adopt. Nevertheless, the judge found that the estimate was formed in good faith. And so we see that acting in good faith is a lower standard than acting reasonably. So where does that leave us? Well, in broad terms, wherever you have a long-term contract, which has some of those features we discussed in the Bates case, collaboration, trust and confidence, that sort of thing, you have a real crack at arguing that it should be subject to the implied duty of good faith. If you get that duty of good faith, it gives you an enormous flexibility, a really broad canvas onto which you can construct all sorts of implied duties. So it's a really powerful tool for a litigator, and obviously a really dangerous tool if you're faced with it. So that was good faith in general. There's one more topic I want to talk about before I hand over to Chloe, and that's the subject of negotiation in good faith. Here, we're concerned with clauses which state that in event X, Y, or Z happening, the parties shall meet and try and negotiate some change in their relationship. And these clauses have, for the past 30 or so years, faced the problem of Walford and Miles. Now, Walford and Miles is a judgment of the House of Lords, and it concerned a lockout agreement in relation to the sale of a business. So an agreement pursuant to which the vendor wasn't allowed to negotiate the sale with anyone else. The disappointed purchaser of this business sought to argue that that lockout agreement was also subject to an implied duty to negotiate, and the duty to negotiate the sale of the business was a duty to negotiate in good faith. Now, the House of Lords held that there was no need for an implied duty to negotiate in good faith in the lockout agreement. But they went further, and they said that even if there was a need for it, the term would be unenforceable. And this was because good faith is inherently repugnant to the adversarial position of the parties when involved in negotiations, and is unworkable in practice. And following the Walford and Miles judgment, there were a number of first instance decisions where such a duty to negotiate in good faith was held to be unenforceable. Typically, those cases concerned duties to try and negotiate a settlement prior to entering into arbitration. Now, that changed with the Petromec decision and the judgment of Lord Justice Mance. In obiter comments, Lord Justice Mance suggested that the Walford case was to be distinguished. He held that where there was an express clause in a contract requiring the parties to negotiate, then that express clause to negotiate would be enforceable. And moreover, once you had an express clause, it would be taken to mean a duty to negotiate in good faith. So an express duty to negotiate carries with it an implicit requirement that that negotiation be in good faith. Those officer comments were picked up by the judge in the Emirates trading case, and he held in that case that the duty to negotiate was enforceable and did require the parties to negotiate in good faith. Now, there's very little case law on this, so we have very little idea of what the content of such a duty should be and what the remedy for breach of such a duty might be. As to content, there are a range of options. It could be that the content of the duty to negotiate in good faith is purely process-driven, so you need to show up and listen to the other side. Or there might be more involved process requirements. Or it could be that the duty is more substantive. So it might be in the right context, a duty to negotiate in good faith carries with it the implication that there is a range of substantive outcomes in that negotiation which the parties need to land in. And if they don't land in that range, whoever's responsible for it has breached the duty. What about the remedy? Well, there are two options. One is what I call the Laverack approach, and that's to ask, what is the minimum possible contractual compliance that the party in breach could have given, and to award damages on that basis. The second approach is what I've called the Hawkulack approach, and that's to ask, what would this party have done had he been negotiating in good faith? So it's a slightly different question. It doesn't give you the minimum possible remedy. It asks what a person acting in good faith would have done. It could give you a greater remedy. And again, we don't know what approach the courts will adopt to remedy these cases. So it's always nice to finish on the note of, I have no idea what's going on. But someone who does know what's going on is Chloe, and she's going to talk to you now about discretions.
Yes, Simon has talked me up. I'm going to talk to you about contractual discretions. I hope I'll bring some clarity to the subject area, but as with implied terms of good faith in general, this is a developing area of the law, and all of the answers are not clear-cut at this point. And I'm sure many of you have come across contractual discretions in your daily practice, and I don't want to bore you, but I think this quotation, which is on the slide, by Lady Hale in Braganza, aptly summarises the issues in this area. She said, there are many statements in the reported cases to the effect that the principles are well settled and well understood, but she said Braganza illustrated that all was not as clear or as well understood as it might be. So for today's purposes, I'm going to focus on three headings in relation to discretions. First, I will contextualise what kinds of clauses we're talking about and what the dispute is normally about. Secondly, I will identify the boundary between contractual discretions and what are commonly referred to as absolute rights. And thirdly, when you do have a contractual discretion, I'm going to consider what standard of review the court will apply in looking at and interpreting the discretion. This involves delving a little deeper into the public law parallels that have already been drawn in the case law, and whether or not those public law parallels might be further extended into the contractual sphere. So first, to contextualize what we're talking about, when we're talking about a contractual discretion, we're talking about a contractual term which charges one party to the contract with making a decision which affects the rights of both parties to the contract. So to take the example of the contract in Braganza, Mr. Braganza was an engineer on board an oil tanker that was in the mid-North Atlantic, and at the hours of between 1 a.m. and 7 a.m. he disappeared. It's not clear for certain what happened to him, but his employers conducted an investigation and formed the opinion that the most likely explanation for his disappearance was that he had committed suicide by throwing himself overboard. As a result of reaching that opinion, his widow was not entitled to death benefits provided for in his contract of employment. And that was pursuant to this clause, which states that compensation for death shall not be payable if, in the opinion of the company or its insurers, the death resulted from, amongst other things, the officer's willful act. So we can see in this clause, the employer or its insurers are charged with forming an opinion and taking a decision as to whether the employee is entitled to death benefits, or rather the employee's widow. And this creates a conflict between the employer, who won't want to pay death benefits, and the employees, survivors, who will want to receive death benefits. And it's open to abuse in the sense that the employer, in forming its opinion, could do so in a manner which bore no relation to the evidence or the facts, or it could take into account totally irrelevant factors or form a totally irrational opinion. So the question is, can the courts step in to circumscribe the manner in which opinions in these kinds of clauses are formed, taking into account the fundamental principle of party autonomy in English contract law? And the answer is yes, and the courts do that by implying a term into clauses which contain discretions to the effect that the discretion must be exercised honestly, in good faith, and not arbitrarily, capriciously, or unreasonably. The UK Supreme Court in Braganza settled on equating this to Wednesbury unreasonableness, which is a public law concept, and decided that in Braganza, the decision-making process and the formation of the opinion by the employer was flawed.
So I was moving on to the second topic that I wanted to discuss tonight, which is where you do have a case that you have a clause that you think is a discretion. Normally, the authorities do show that there's an initial dispute about whether or not the clause is a discretion or not. And so I want to talk now about how you identify a discretion. The case law is quite disjointed on this, and I suspect that's why most cases do involve an initial dispute about whether or not a clause is in fact a discretion. But after doing a bit of trawling through the case law and looking at the analysis applied by the courts, I think there are two limbs to a discretion. The first limb is that it requires the exercise of judgment, the making of an assessment or an evaluation to which there's no single right answer, and upon which different people acting rationally might disagree. And the second limb is that exercise, assessment, or evaluation is to be undertaken by one of the contracting parties as opposed to the court. So it's under the second limb that you can see why public law parallels have been drawn. On a proper construction of a discretion, the court is not to substitute its own views for that of the decision maker, but to review the decision-making process and the outcome. And that's similar to a court's role in judicial review. And in my view, the dicta of Lord Justice Mance, as he then was, in Gann Insurance, best conceptualises the two-pronged test. Now, as you can see on this slide, the relevant clause was a claims cooperation clause in a reinsurance policy, and it required the prior approval of the reinsurers for any settlement or compromise of an underlying loss. So one of the issues for consideration was the circumstances in which that approval could be withheld. Lord Justice Mance, who wrote the lead judgment in that case, considered that this clause contained a discretion which had to be exercised in good faith. But it's what he said in construing this clause as a discretion which I find most illuminating in this judgment. And he said four things that really helped me when construing a clause and deciding whether I think it's a discretion or not. The first thing that he said was the reinsurer was entitled to exercise its own judgment as to the appropriateness of a settlement, regardless of what others may think. That engages both limbs A and B of the test for a discretion. He recognised that inherent in the claims approval clause was the possibility of disagreement as regards the merits of a proposed settlement based in the evaluation of settlement to be undertaken. He also said that the right to withhold approval was that of GAN Insurance and no one else's, and that the court would not substitute its own view of the reasonableness of a reinsurer's decision to withhold approval. And so that really goes to limb B and what the court's role is in reviewing a discretion. And finally, he said, the level of appropriate settlement and the point at which insurers should dig their heels in relation to a disputed insurance claim are often difficult matters of judgment or feel on which different people may well hold different views. And for me, I think that really conceptualizes what limb A is getting at in terms of it being about evaluation, assessment, and importing a degree of subjectivity into the analysis. Just for reference, GAN is a relatively old authority, but it has been approved more recently by the Court of Appeal in Equitas Insurance Limited, and Lord Justice Leggett was also sitting in that case for reference. Just to distinguish then a discretion with clauses that are often referred to as absolute rights. Usually, these clauses turn on whether conditions or facts giving rise to the right are objectively made out. So it's not a matter of evaluation, subjectivity, or feel. And secondly, if there's a dispute about whether the conditions or facts are made out, it's for a court to resolve on the balance of probabilities rather than a party to the contract. So now what I'm going to do is do a short survey based on a couple of contractual clauses. And I'm going to ask you to type to me in chat, or you can do it publicly, privately, whatever you prefer, and tell me whether you think it's a discretion or not. Please don't be shy. As I said at the start of this, most of the authorities contain an initial dispute about whether the clause is in fact a discretion. So you'll not be alone if you get it wrong. The first clause I want to look at is the terms of business for a foreign exchange trading platform. One of the clauses was entitled abusive trading, and it stated that transactions that rely on price latency opportunities may be revoked without prior notice. So let me know whether you think this is a discretion or not. That one is not a discretion, and that's from the case of Sherbanova. And just to take you through the test, limb A was not satisfied because there's no judgment or evaluation to be carried out by the trading platform. There's either price latency or not. If the clause had read, if in the opinion of the trading platform, that could have made a difference to the interpretation of that clause, arguably. Limb B also isn't satisfied because the trading platform is not the decision maker. On construction of the clause, price latency is a matter of objective fact, which would be decided by the court in the event of a dispute. Second clause is an agreement between two banks, which states in the event of default, the non-defaulting bank was responsible for making a determination as to the value of the sums owing to it on the date of default. So do you think that's a discretion or not? Cast your votes. So that one is a discretion, and that's the Court of Appeal Authority in Sockamer. In this clause, limb B is satisfied, as it was the non-defaulting bank which was charged with making the determination. And LeMay was satisfied. Lord Justice Ricks in that case said that the bank was conducting an evaluative exercise in valuing the sums which left room for subjective judgment. So therefore, good faith restrictions were implied into that term. Third clause is an unintentional non-disclosure clause in two professional indemnity policies, which were underwritten by the defendant. And in material parts, that clause read as follows: in the event of non-disclosure or misrepresentation of information to us, we will waive our rights to avoid this insurance clause, provided that you are able to establish to our satisfaction that such non-disclosure or misrepresentation was innocent and free from any fraudulent conduct or intent to deceive. So what are your views on this? Do you think this contains a discretion or not? So this is a discretion, and it's from the relatively recent judgment of UK Acorn Finance. It was held to be a discretion in that case because the contractual clause confers the decision-making power on the defendant. Note the use of the terms able to establish to our satisfaction being important, and they go to limb B. Also, the nature of the contractual term was held to be one by which one party to the contract was given power to form an opinion as to relevant facts, which engages limb A. And the final clause that I will torture you with is a commercial agency clause that provided that it would operate for a 3-year period subject to completion of a successful review in January 2012. Assuming both parties are satisfied following the review, both parties will commit to a further 2-year consultancy period. So is the decision to renew or not renew subject to discretion, obligations of good faith? So this one is not a discretion, and it was held not to be a discretion because it's essentially a right of termination. And termination clauses are treated somewhat discreetly in the area of contractual discretions. As a general rule, express termination clauses in contracts have not attracted the implication of a term of good faith. And there's been a pretty consistent body of case law from Redder and Flag from the UK Privy Council in 2002, right through to Tackett and Rockrose and Cathay Pacific, which are 2 decisions from this year in the Commercial Court and Chancery Division. Cathay Pacific, John Kimball QC, sitting as a Deputy High Court judge, held that the clause in that case was an option clause in a long-term aircraft engine maintenance contract. And he said that clause was akin to a partial termination clause and was a power by definition inserted for the benefit of the terminator, such that it was not appropriate to apply a Braganza duty of good faith. One oft-cited outlier is MSC Mediterranean Shipping, where there's a suggestion in that case that termination clauses ought to be treated like every other clauses in contracts, and discretion should be imported where it's appropriate to do so and where they can be interpreted as being discretionary in nature. No prizes for who the judge is. It was Mr. Justice Leggett when he was a High Court judge, so there may be more to come on the front of termination clauses if they get to appellate levels. I've also just put on the slide closeout clauses because they're construed as termination clauses in the case law, and I've cited Suckton Financial as an example there, but that's also pretty consistent. There are normative arguments and criticisms of this separate treatment of termination clauses and whether they represent doctrinal incoherence in the area of contractual discretions. I think that's a talk in itself. I know Simon's got particular views on this, so I'll leave him to entertain you on that subject. Watch this space in due course. I'm now going to move on to the third topic that I want to discuss, which is once it's been determined that a clause is a discretion, what is actually required. So the UK Supreme Court in Braganza said that what is required is that the decision reached pursuant to the discretion must be one which is Wednesbury reasonable. And Wednesbury is a judicial review term. Lady Hill helpfully summarised what that meant in paragraph 24 of Braganza. It's a two-pronged test. The first prong goes to the decision-making process, whether the right relevant matters have been taken into account, irrelevant matters discounted in reaching the decision. The second limb goes to outcome, whether even though the right things have been taken into account, the result is so outrageous that no reasonable decision maker could have reached it. Just a word of caution, this is not the same as objective reasonableness. And there's a nice dicta from Lord Sumption in Hayes and Willoughby where he draws the distinction between rationality, which is another term for Wednesbury reasonableness, and reasonableness in the objective sense of the words. So just be careful that you're not applying the standard of what would the man in the Clapham omnibus do pursuant to this clause, because that's not what Wednesbury reasonableness is getting at. I've cited Crowther and Arbuthnot in the second bullet on this slide, just as a word of warning that sometimes the clauses are going to be construed as importing objective reasonableness as opposed to reasonableness in the discretionary sense. And I've just cited the clause there that the judge considered to be a standard of objective reasonableness. So you just have to be aware of that possibility. But if you're dealing with a real discretion, it's Wednesbury reasonableness and not objective reasonableness. So that's all very well stated in the abstract, but what does a court actually do when making the two-pronged Wednesbury assessment? What factors does it take into account? In public law, there's a pretty large body of jurisprudence built around the idea that Wednesbury reasonableness is a sliding spectrum. The intensity with which a court scrutinises the outcome of a decision by a public authority in judicial review varies from case to case. So where you've got fundamental rights in a public law case, a particularly intense form of review is undertaken by the courts. By contrast, if you've got a decision which relies on political policy, where democratic accountability is paramount, where particularly empirical or specialist analysis is required, the courts take a less exacting approach to scrutinising the decision-making process and outcome. But is this sliding spectrum then translatable into the contractual sphere? Well, first let me say why I'm talking about this. I think it's important as a matter of practice for two reasons. From an advisory perspective, if you are dealing with a contractual discretion, you do need to be in a position to advise clients what kinds of decision-making processes they need to implement, how sophisticated that process needs to be, the length of any paper trail they need to create when making a decision, and the strength of any justification that needs to lie behind one decision over another. Secondly, from a litigation perspective, framing a court's role at the outset as a reviewer of a discretion by reference to intensity of review and deference to the decision maker will have an impact on the amount and nature of evidence the court will require to make out your client's case, as well as the court's approach to that evidence and how much scrutiny it applies to it. So how does it translate into the contractual sphere? Well, admittedly, there is not a sophisticated body of case law. As I said at the start, this is a developing area. But the intensity of review is something, in my view, that the Supreme Court very much had in mind in Braganza. And this has come out more recently in Cathay Pacific. The judge in that case recognised that this was a developing area in commercial contracts. And at paragraph 169 of his judgment, he said, the choice is not a binary one between applying a Braganza duty or not. A fetter may be implied, but it may be in a more limited form. And another way of looking at this issue was put nicely by Chief Master Marsh in UBS and Rose, which he referred to as the scope of the implied term of good faith that is to be implied. So what I'm going to do for the remainder of the talk in the next 5 minutes is draw the dicta together that I pulled out from the contractual cases to paint a picture of what factors cause a court to apply anxious scrutiny or more intense scrutiny to the exercise of contractual discretion versus the court taking a light touch approach to reviewing a discretion. So as you can see on the left-hand side in the red box, where a implied term arises in the context of a contract where there's a special relationship between the parties, that will attract a more intense form of review of the discretion. Both Lady Hale and Lord Hodge in Braganza said that that was an employment relationship where there was an implied term of mutual trust and confidence between the employer and employee, and therefore a more rigorous form of review was appropriate. The court also said in Braganza that based on the evidence, it was very unlikely that Mr. Braganza committed suicide, and they looked back through his psychological history and religious beliefs in reaching that conclusion. And as a result of reaching that conclusion, the Supreme Court said the employer needed particularly cogent evidence to justify forming the opinion it did. And it wasn't acceptable to just accept the view of the investigation committee. This was also endorsed by His Honour Judge Pelling recently in Acorn Finance at paragraph 65. And he said in that case, the decision maker had to determine whether there was a fraudulent non-disclosure of information. And he said it was more probable that a misrepresentation was made innocently or negligently rather than dishonestly. So the decision maker had to have very good reasons in reaching a conclusion of dishonesty in evaluating. Braganza also discussed the fact that the seriousness of the consequences on the widow of Mr. Braganza meant that it was appropriate for the court to look more closely at the decision-making process and outcome. There's authority for the proposition that if you've got a decision maker with large resources and expertise in a particular area or a particular decision-making process, that will attract higher expectations as to the quality of the decision-making process and outcome. Process will need to be more sophisticated and decisions backed up by evidence. That came across in Braganza and also in the commercial context in BHL and Lumi. Another factor to pay attention to is the nature of the exercise to be undertaken by the court. So in Braganza, Lord Hodge said, in this case, what we're essentially being charged with doing is reviewing the fact-finding undertaken by the employer, which courts are very good at doing. So therefore, it's appropriate for us to look at that fact-finding process more intensively. And he said, by contrast, if we were, for example, looking at a discretionary bonus clause in an employment contract, that imports a large degree of subjectivity on the part of line managers and those in more senior positions as to the performance of an individual. And he said that would probably be less appropriate to review intensively. And finally, in the red category, there is case law to say that where there's an imbalance of power between the contracting parties, it's more appropriate for a court to take a more searching approach in its review of the discretion, because imbalance of power is more, will give rise to abuse more easily than where there's a balance of power between the parties. So that obviously will arise in employment contracts and consumer contracts, but equitous insurance was an imbalance of power of knowledge between the insurer and the reinsurer, and Lord Justice Mayles alluded to the fact that there was an imbalance in reviewing the discretion in that case. And just to briefly contrast the red zone with where a court will step back and take a less intensive form of review. Lady Hale and Braganza said that contractual decision makers in general probably won't be held to the same high standards as the modern state, which is good to know. Where contracts are professionally drawn up and the terms have been negotiated between the parties, the courts are generally going to give the parties the space that they negotiated to exercise their discretion. And they're not going to interfere willingly. That kind of links back to the balance of power between the parties as well. Tied to this is where you've got two commercial entities, there's an expectation that both will have regard to their own interests, and the court won't expect anything else, so that the court won't really want to interfere with the exercise of a discretion. So, for example, in PAG, the Court of Appeal said that RBS was not required to balance its interests against those of PAG because they were both commercial parties, but needed to pursue, at the very least, legitimate commercial aims and couldn't, say, vex PAG maliciously, but that's a much lower standard. To take you back, another theme is that where a decision has to be exercised in a commercial context with speed and efficiency, the courts will not hold them to a standard of perfection. And finally, just to say, when you are in the land of light touch review, at the very least, it's important that your client can demonstrate that the discretion's actually been exercised. So I've cited the cases of Watson and Watchfinder and BHL and Lemmy, both decisions of His Honour Judge Waxman, as he then was. And in both of those cases, the decision maker either applied a blanket policy or just made a decision without really considering the issues. So His Honour Judge Waxman said that those cases essentially amounted to fettering of a discretion, complete fetters of discretion rather, and as such, the implied term of good faith had not been exercised properly. So you must at the very least be able to show that you did apply your mind to the discretion. As regards the future of this area of the law, it is developing. I think Braganza and the public law parallels are here to stay. It's a Supreme Court authority. That said, the Supreme Court looks very different now than it did in Braganza, with Lord Leggett sitting on the bench now. You've also got two individuals who I think are sceptical of the public law parallels, and they are Lord Sales and Lady Arden, who have both expressed views on the lack of utility of public law parallels. So I think you do need to pay attention to appellate law in this area in the years to come, because I don't think Braganza is the end of the road for the long-term future. That concludes what I have to say on discretions.